Can federal law override state law? Have you ever wondered how federal laws interact with state laws? This question is at the heart of a complex relationship that shapes our legal system. The answer lies in a principle known as preemption, which is rooted in the Supremacy Clause of the United States Constitution. This clause states that the Constitution and federal laws made under it are the highest form of law in the country. So, when federal and state laws clash, federal law takes precedence. The Supremacy Clause can be found in Article 6, Section 2 of the Constitution. It clearly establishes that if Congress passes a law within its constitutional authority, that law will override any conflicting state law. This means that states must comply with federal laws, even if they have their own regulations on the same issue. Preemption can happen in two main ways. The first is express preemption, where Congress directly states in a federal law that state laws on a specific topic cannot be enforced. The second is implied preemption, which occurs when a federal law does not explicitly state it preempts state law, but courts determine that it is impossible to follow both laws or that state law interferes with federal objectives. Congress has exclusive control over certain areas like immigration, bankruptcy, and currency. In these areas, states cannot create conflicting laws. However, there are areas where both Congress and states can have authority. Even in these shared areas, if there is a conflict, federal law can still take over. It's important to note that states are not forced to enforce federal laws or create regulatory programs that Congress mandates. For example, the Supreme Court has ruled that the federal government cannot, requiring state law enforcement to conduct federal background checks for handgun purchases. States can also choose not to enforce federal laws they believe are unconstitutional, but they cannot prevent federal authorities from enforcing those laws unless a court has ruled them unconstitutional. This dynamic creates a balance where states maintain control over many local matters but must yield to federal law when there is a direct conflict or when Congress has made its intent clear. State attorneys general often take legal action in preemption cases to protect state laws from being overridden by federal claims. They focus on understanding the scope of federal preemption and what Congress intended. In practical terms, while states have the power to create their own laws and policies, federal law can indeed override those laws when there is a constitutional basis and clear congressional intent. This ongoing interaction shapes the political environment and the relationships between state and federal governments, requiring careful consideration by state policymakers to protect state interests while complying with federal law.